Do police officers have an incredible power of auditory recognition? What do I mean by that? Well, we know that marijuana has a distinctive appearance, taste, odor, and even perhaps feel. But does it have a distinct sound? Can a police officer really claim that he heard somebody load marijuana in the back of the car without making a visual observation? Well, this is what we're going to look at today. And before we go on, I want to thank you for watching me here on YouTube. If you're new to the LAWSTACHE channel, hit that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to LAWSTACHE.com and check out some of the merch, including the Do Not Arrest This Person t-shirts. Thanks for watching.
Quick message from LAWSTACHE. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the LAWSTACHE YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the LAWSTACHE YouTube page. That's LAWSTACHE.
Today we're discussing United States versus Andrew Thomas, which is the Ninth Circuit case, and it deals with the Fourth Amendment and police officers' apparent ability to hear and recognize the sound of marijuana. But first, let me give you some factual background. FBI agents gave a tip to a local sheriff's department. The detective was told that he might want to pay a little bit of a closer attention to a certain house because there's a possibility that narcotics could be found inside. So the detective establishes surveillance of this particular home. He sees 4 vehicles parked in front of it. A white Oldsmobile, a silver Grand Am, and 2 other disabled vehicles. Around 9 a.m., he sees 4 individuals leave the house, get in the Oldsmobile, and drive off. He follows the vehicle, but unfortunately loses it. So he then goes back to the house and continues their surveillance. Around 1 p.m., he sees another individual leave the house and get into the Grand Am. This time the detective radios other officers to pull over the vehicle. They do so, they search the car, but find nothing. There's no evidence of any drug activity. The detective continues the surveillance, and then about an hour later, around 2 p.m., he sees Mr. Thomas, the driver, and a passenger in an El Camino arrive to the house. They open the garage, and Mr. Thomas backs in the El Camino into the garage about halfway. Now the detective could now only see the front of the car and not the back. He then heard what he thought were 3-4 thumps. This, he says, was the sound of marijuana. Now, during the suppression hearing, he first testified that he thought that something was being loaded in the car. But later, when pushed a little bit by the defense, he said that this was a distinctive sound of packages of marijuana being loaded. So, after this auditory observation, the detective, asks other officers to pull over the vehicle because at the end of the day, the vehicle left the garage after supposedly the drugs were loaded. Now the officers then pulled over the vehicle and in fact found some marijuana in the car. Now, Mr. Thomas later claims at the suppression hearing, and of course now on appeal on the Ninth Circuit, that this was an illegal search. This was also an illegal stop of the vehicle. He says there was no reasonable suspicion to pull him over. The officer cannot rely on this incredible power of auditory observations and recognition of the sound of marijuana. And because this is a Fourth Amendment case, let's first discuss the Fourth Amendment. The Fourth Amendment allows government officials to conduct an investigatory stop of a vehicle only upon a showing of reasonable suspicion, a particularized and objective basis for suspecting the particular person stopped of criminal activity. Reasonable suspicion requires specific, articulable facts which, together with objective and reasonable inferences, form a basis for suspecting that a particular person is engaged in criminal activity. The government argues that three factors amounted to reasonable suspicion and justification to pull over Mr. Thomas in his El Camino as he drove away from the house. The first factor is that the detective received a tip from the FBI agents. Number two, all of that foot traffic that the detective observed going in and out of the house on that particular day. And finally, the third factor are the 3 or 4 thumps that the detective heard what he believed were sounds of packages of marijuana being loaded in the back of El Camino. Those are the three factors, and we're going to look at them one by one. First, let's focus on the FBI tip. Of course, local law enforcement can rely on other agencies in getting information and supporting the notion of reasonable suspicion. But if they rely on some other information from another agency, that information itself must also be supported by reasonable suspicion. And what do we have here? We have an FBI agent telling a local detective about a possibility of some narcotics that could be found at a particular location, but they don't say anything about the individuals who are in the house, the vehicles, or what is the conduct that they're thinking about when saying that drugs might be found inside, and that the detective might want to look at the house a little bit closer. So again, this is all speculation here. And when law enforcement are relying on a tip, there must be sufficient indicia of reliability and some corroboration by law enforcement in order for it to be upheld in court. And here the Ninth Circuit says that the information was just too general. It was too vague, and it did not provide any reasonable suspicion to pull over the vehicle. And of course, the local detective could not even corroborate any of the information with his own surveillance because he didn't even know what he was looking for. So at the end, this particular factor did not provide any reasonable suspicion to pull over the vehicle. Now, in terms of the second factor, we're talking about all the foot traffic that the detective observed going in and out of the house. He says this is consistent with drug activity. But the Ninth Circuit says this is also consistent with any form of activity you expect at the house. We know nothing about the individuals that the detective observed. Are these people who live there? Are there family members? Are there visitors? Are there strangers? Who are these people, says the Ninth Circuit. And in fact, if there's one thing that we know about one of the individuals that the detective observed, it is that that person was not involved in drug activity. Remember, the officer observed one individual leave the house and get into the Grand Am. That vehicle was pulled over, and then the officers found nothing in the vehicle, nothing to indicate that drug activity was at the vehicle or at the house. There was no presence of any drugs in the car whatsoever. So the court says, again, this factor does not provide reasonable suspicion to pull over Mr. Thomas hours later. And finally, the third factor, the sound of marijuana. After 19 years and hours observing and surveilling stash houses, the government says that this particular officer had experience to tell the sound of packages of marijuana being loaded in the back of El Camino. After all, he heard 3 or 4 thumps that came from the inside of the garage. But the court doesn't buy it. The Ninth Circuit says, how is this sound any different from any other packages that could have been loaded into the car? After all, marijuana might have a distinctive appearance, taste, smell, and perhaps even feel. But how does it have a distinctive sound? The court does not believe that police officers have this incredible power of auditory recognition. So the court says, if we take all of these factors on their own, or as we say, in totality of circumstances, as we take them together, they do not provide reasonable suspicion to pull over the vehicle. And because there was no reasonable suspicion, this means that the stop was in fact illegal and in violation of the Fourth Amendment. And what do we do when the court deems that the stop is illegal and the Fourth Amendment is violated? Well, all the evidence that's found against the individual must be suppressed as fruits of the poisonous tree, meaning that none of the evidence can be used against the individual in trial. And without the drugs, all of the charges should have been dismissed. Here's how the court concludes in terms of reasonable suspicion in this case. A hunch may provide the basis for solid police work. It may trigger an investigation that uncovers facts that establish reasonable suspicion, probable cause, or even grounds for a conviction. A hunch, however, is not a substitute for the necessary specific, articulable facts required to justify a Fourth Amendment intrusion. I hope you enjoyed this video and learned something today. And if you did, give this video a thumbs up. If you're new to LAWSTACHE channel, hit that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to be a superstar and support this channel, consider going to LAWSTACHE.com and check out some of the merch, including the popular Do Not Arrest This Person t-shirts. Thanks for watching.